Next is State versus Cromedy. If counsel could please step forward. May we please have appearances of counsel?
On behalf of Mr. Zaire,
Good morning, Your Honor. Jennifer Tunisia, Deputy Attorney General, on behalf of the state.
Welcome, counsel. Mr. Rockoff, please go ahead.
Your Honor, before I begin, I would just reserve up to 5 minutes rebuttal time if necessary.
We'll have you back perhaps for less than that.
So, Your Honors, in 2013, the legislature added J to 39.5. The issue here is whether J is a substantive first-degree crime of which defendants may be convicted, or whether J is a first-degree sentencing enhancement of the second and third-degree crimes in A, B, C, and F. So based on the plain language, this court should hold that J is its own substantive first-degree crime, unlawful possession of a weapon by a person with a prior narrow conviction. So the Attorney General and I agree that the legislature targeted recidivists. They accomplished that, however, by adding the only first-degree crime in 39.5. A, B, C, and F are all second and third-degree crimes. The first-degree crime in J is more serious than the second and third-degree crimes in A, B, C, and F because it significantly increases the risk of exposure to long prison sentences. Even the bottom of the first-degree range, 10 years, is at the top of the max for second degree. And of course, at the top of the first-degree extended term range, defendants can get a life sentence. So as a measure of how successful the legislature was in targeting recidivists with the first-degree crime in J, we are seeing decades-long extended terms, like in Canada, for example, where the defendant there was exposed to 30 years in prison for not having a license. But the Attorney General is wrong that the legislature simultaneously added a mandatory minimum to J's already elevated first-degree crime. As the appellate division said in the Canada's opinion, nothing in the act or its legislative history even hints the legislature intended such a dramatic increase as to both create a new first-degree offense and to require a Graves Act term. So for 3 reasons, the plain language required the judge here to exercise discretion as to a parole bar. You should therefore remand for resentencing because this wasn't done. First, judicial discretion is required because the legislature chose to exclude J from the Graves Act language. So the 2013 law, the legislature added F of 39.5 to 43.6C's, the Graves Act's list of convictions that qualify for the Graves minimum. But the legislature didn't add 39.5J to the Graves list. By contrast, in the same law, the legislature did add J to 39.5H's list of convictions that bar intensive supervision. So the legislature employed J in one place, 39.5's list of convictions, yet excluded it in another, the Graves list of convictions. So it shouldn't be implied or excluded. It's a principle of statutory construction that the judiciary shouldn't add language to section X that the legislature chose to include in section Y, but left out of X. Second reason judicial discretion is required. It isn't just that, so the legislature distinguished J convictions, which aren't in the Graves Act, from A, B, C, and F convictions, which are. So J says it, quote, is a first-degree crime, not a sentencing enhancement, a first-degree crime. And the legislature's list in H specifies that being, quote, convicted of a crime under J, in other words, violating A, B, or F, while having a prior NERA conviction, is distinct from being convicted of A, B, or F. So A, B, and F convictions are listed separately from J convictions, and they're not surplusage. Similarly, the legislature's list in H specifies that being convicted of a crime under J, which would include violating C while having a prior NERA conviction, that's distinct from being convicted of C. And we know that because J convictions are listed as barred from ISP and C convictions aren't. So the legislature unambiguously distinguished J convictions from A, B, C, and F convictions in 39.5, and they still kept J out of the Graves Act. Third reason judicial discretion is required, canon of lenity. Even if there's some ambiguity, you should construe the plain language to make the Graves Act inapplicable to J. So Canada has held the lenity should prevent application of the Graves Act to 39.5 convictions. That's exactly right. The legislature didn't give a clear statement here of any first-degree Graves Act crimes in 39.5, let alone 4 first-degree Graves Act crimes. The court shouldn't impose mandatory minimums on first-degree convictions, depriving judges of discretion without a clear affirmative statement from lawmakers. And it's for that reason that the model jury charge prosecutors committee, the prosecutors statewide, and other appellate division panels have all construed first degree J as a separate conviction from second and third degree A, B, C, and F convictions. And again, J isn't enumerated as a qualifying greatest offense. So to close my opening, because the legislature's plain language unambiguously requires judicial discretion in imposing a parole bar here, and the sentencing court erroneously held that it lacked discretion, this court must be remanded for resentencing. That does conclude my opening statement. I would go on unless there's any immediate questions to just further discuss the plain language of 39.5. So it shows that I think J is, as I've just discussed somewhat at length, that J is unambiguously a distinct crime. So J says it is a first degree crime. In ordinary usage, that's worded as a prosecutable crime, not as a sentencing enhancement. So this isn't
Specifically says a violation of subsection A, B, C, or F of this section by a person who has a prior conviction of any of the crimes enumerated in D is a first degree crime. So one cannot possibly be charged or convicted of subsection J without having violated A, B, C, or F, correct?
Yes, that's correct, Your Honor. Our contention is that J is a separate crime where A, B, C, and F are one of the predicate elements.
What are the predicate elements?
Predicate elements, yeah.
But this is a one-count indictment in this case, correct?
There's actually, I think there's 3 counts. There's 2 separate indictments. One is so he was only charged with first degree J, not second degree B as well. If that's what Your Honor is indicating.
Only count 2 relates to the unlawful possession of a weapon, and that collapses the language with respect to 5B1. Okay.
Correct. I'm looking at the same thing. It specifically says, quote, contrary to the provisions of NJSA 2C:39-5B1 and NJSA 2C:39-5J. So it does list both.
That's correct, Your Honor. In this indictment, it does list both. But I would point out this isn't like this state's, I think, trying to argue that that he was in fact convicted of both, but it is a single count of first degree unlawful possession of a weapon.
You refer to it as a predicate. Tell us, what are the elements of count 2?
So it would be what the model jury charge committee interpreted. Interpreting the committee interpreting the crime as substance. So the model charge tells jurors that count X charges the defendant with possession of a handgun by a previously convicted person. The state must prove all elements. So the elements are what the elements of B are. I'm not disputing that it's that the state must prove B in order to prove J.
And the jury gets charged on B in full.
You can see indictments, and I listed some in my brief, where the state has charged like J, first degree J, as a separate count from second degree B, right? So that
didn't happen here. So focusing on this example here, the jury gets charged on what they need to find in order to make a determination that section B has been violated, and the same for J.
So it's when you're pleading guilty to an offense, you're pleading guilty to a particular count. This isn't a case where, so like by analogy, you might plead to, for example, 35-7, a school zone offense. And in the course of pleading guilty to 35-7, you might establish facts that amount to a 35-5 conviction. So the analogy is, the defendant, the way we're construing J, first degree J, and urging this court to do so, is that first degree J is its own separate offense. It's separate from second degree B, but B or A, B, C, or F in the case of a defendant who possesses an assault rifle or one of the other firearms listed would be an element of J.
Can you state succinctly for us, what are the elements of a conviction under J?
Yes. So I have the model jury charge in my appendix. I can go through that with you. So In order to convict the defendant, this is on DSA 40, the state must prove each of the following elements beyond a reasonable doubt. That there is a handgun. 2, that the defendant knowingly possessed the handgun. 3, that the defendant did not have a permit to possess such a weapon. And 4, that the defendant has a prior conviction of an enumerated crime in 7.2 NARA.
So the first three elements that you mentioned, those are the elements for a violation of B.
Yes, that's correct. Yes.
So does a conviction of a single count that identifies B and J encompass a finding of guilt with respect to B?
No, Your Honor. I mean, the way that I would construe it
How
is
could it
that
not though? Because here the judgment of conviction specifically lists B1,
I do think that
convicted of B1. and
Yes,
he
Your
pled
Honor.
guilty to a violation of B1.
I do think that the judgment of conviction there is wrong. It's clear from looking at the plea, like been notated incorrectly. That it's clear from looking at the plea colloquy that my client pled guilty to only a single count, first degree unlawful possession of a weapon,
But
which
the single count charged contrary to B1 and J, correct?
yes, that's the way the prosecutor worded the indictment here. I would point out though that even in the grand jury presentation, the prosecutor specifically referred to B as being one of the elements of J. And that's on page 38 of the grand jury transcript, lines 12 to 14. So, you know, my
Your client never moved to have the indictment changed or moved to not plead guilty to dismissal of that count that listed D1 or J, correct?
I don't know that he moved to amend the indictment. Our position is that the indictment itself is fine and that how it's interpreted is dependent on the outcome of the case here today. If this court finds that J is a substantive statute, then the indictment should be construed as he's pled guilty to a single count, first degree J, with B as an element. On the other hand, if the state were to prevail, then he's pled guilty to first degree B, where J is noted in the indictment as a sentencing enhancement. So I wouldn't hinge my argument on that.
You're talking about the plea. Can we stick? I want to stick with the plea for a second. At the plea transcript, on page 5, the judge says, I'm going to cross out under J. It's just pursuant to Graves Act. So if the judge is saying, I'm going to cross out under J, it's just pursuant to Graves Act, how is it that he pled guilty to J?
He pled guilty to J because J, as I'm attempting to explain, is the only substantive offense in 39.5 that is a first degree crime. So just because the judge crossed out J doesn't change the fact of what the statute actually means. I mean, I do think that the judge below misunderstood that it's clear the judge thought that J wasn't a substantive offense, but nevertheless, he took the defendant's plea to first degree unlawful possession of a
Sorry,
handgun.
can you say that one more time? I didn't hear. It's clear the judge below misunderstood what?
It's clear that both the law division and the appellate division thought that J was a grading statute or a sentencing enhancement rather than its own distinct offense. But if this court were to rule otherwise and to reverse, as my client is urging you to do so, then it's clear that he pled guilty to a single count, first degree unlawful possession of a weapon, which, as I'm arguing, is that J is the only first degree crime in 39.
How do you respond to the appellate division's reliance on the doctrine of absurdity? And in particular, if someone's convicted of a second degree unlawful possession of a handgun without a permit, under Graves, that person could get a 10-year prison term with a period of 5 years of parole and eligibility.
So
If that same person were convicted of that same B1 offense, but it's elevated to a first degree relying on J, the appellate division points out that that person would not be subject to a period of parole and eligibility, unlike the second degree offender. How do you reconcile that?
So, I guess I would respond in 3 ways. First, and I'll go through each of them. But first, there is precedent for the legislature like exchanging the kind of mandatory minimum that's present for second degree B for essentially a higher maximum, right? More sentencing exposure without a minimum for an elevated like first degree crime like in J. So I guess I'll go through all of them and then go back. So second, I would
I'm
point out
sorry,
that,
I don't understand the import of that. Can you explain it a little
Sure.
more slowly?
so let me just walk through that as the first reason is why I would justify the rationalization. So, some examples, right? The legislature requires, has made this trade-off in at least some other context, right? So there's the 35-7 school zone offense, which is a third-degree crime, and it requires a minimum of the legislature has required that defendants serve a mandatory minimum of at least 3 years upon being convicted for this third degree. Then they enacted also a second degree offense, 35-7.1, within 500 feet of a public building, which can include schools. No mandatory minimum, right? You can be convicted of a higher second degree offense, but without a mandatory minimum. So the second degree offender, for doing committing the same conduct, could potentially be eligible for parole before the third degree offender.
So in this case, how soon could a defendant sentenced to the mandatory minimum of 10 years under the first degree 5J offense be eligible for parole and potentially released if Graves Act doesn't apply?
I'm not a parole expert. My understanding is there's generally, in the absence of any parole disqualifier, there's eligibility for parole after I think about a fifth of the sentence. So it would be 2 years.
Sorry, a fifth of the sentence?
A fifth of the sentence. That's my uninformed understanding of how the parole
So fairly soon, even though there's this higher mandatory minimum and maximum for the first degree offense,
Right.
someone sentenced to 10 years or even 15 years could potentially be eligible for parole within a few years and serve less than someone convicted of a second degree offense for which the Graves Act applied.
Your Honor, I acknowledge that's a possible outcome. I mean, I have a couple responses to that. Number one, a defendant, of course, may ultimately serve the maximum, especially someone who's a recidivist offender, right? So just because somebody is in fact eligible for parole doesn't mean they're going to get parole. And that, of course, goes to, well, the first degree sentences have higher maximums, right? So my client happens to have had a recommendation of 10 years, but like somebody like Canada's got a recommendation of 30. First degree, of course, can go up to life. You could end up with, and this goes to my second point on why the legislature would be able to rationalize this kind of exchange, that you could end up with even a discretionary pro disqualifier, including a discretionary pro disqualifier of up to one half of life. And that's why I think the Canada's opinion actually found specifically that this wasn't an absurd trade-off.
Could I ask you something about that though?
Yes.
Isn't it the case that it's actually a third of the sentence on flat sentences that somebody would normally be eligible on their first eligibility?
So that could be the case.
And
Instead
beyond
of
beyond that, you're talking about somebody who with a 10, let's say, as a 10 at the bottom of the range of a first degree. By its very nature of where they're being charged in J, they have a prior NERA offense, which means that they have previously served an 85% sentence with a 3 or 5 year parole sentence after the fact, right? So they've already been on parole for either 3 or 5 years on that prior NERA offense, and they've got a first degree offense, and all of those factor into the parole designation. So they're being compared very differently from somebody who is sentenced in the second degree range because of all of these other factors that have to do with them being sentenced under J.
That explained it better than I could. So it goes to the point that it goes to the point that even without a specific mandatory minimum term, somebody who has a prior NERA conviction is probably or may not get out within either a fifth or a third of the time. The other point is that.
So before you go on, can we go back to Justice Ficciali's question for a second?
Yes. Yeah.
So you were beginning to talk about how you thought the legislature could rationalize J as an independent offense, but in the sentencing transcript, defendant's counselor doesn't make that argument, instead calls what happened with J an unintentional drafting gap. So which is it? Is J a rational effort by the legislature to to sentence in that way, or is it an unintentional drafting gap?
Your Honor, I would frame it differently than my client's trial counsel. I do think that it was intentional in the sense that the legislature specifically never intended to add a mandatory minimum to the Graves Act for Jay. I would also point out for this sentencing transcript here in particular, defense counsel did ask for a 10 flat sentence in contrast with the prosecutor's request for a 10 with 5. So it's clear that the defense counsel, my client's trial counsel below, in fact, did ask the trial court to exercise its discretion not to impose a discretionary pro disqualifier. But I would use that as an opportunity to.
Before you get to your third point, if I could come back to something else, B1 is a second degree offense.
Yes.
And it's identified in the Graves Act.
Yes.
To find the defendant guilty of this violation of J in this case, the court necessarily would have had to conclude that there were sufficient proof of a B1 violation, correct?
Yes, Your Honor, that's correct.
So is it then possible, if you're correct about J and it's a standalone offense, that the defendant would nonetheless be subject to a Graves Act, to the Graves Act, relying on B as a second degree offense?
So that's what the state is arguing should happen here. That essentially, because see, our position is that B here, notwithstanding the confusing language of the indictment, that B is an element of the first degree crime of unlawful possession, which could only refer to J. It's possible that in other cases. So not only does a judge have discretion to impose a pro disqualifier under 46(b), but prosecutors have charging discretion to see convictions on 2 counts. Right? They can indict a defendant for 1 count of first degree J and a 2nd count for 2nd and 3rd degree A, B, C, and F. I understand that you're looking at this 1 count and saying that both are there in this case. I would contrast though this indictment with the indictments discussed by the appellate division in like a dozen unpublished cases: Denby, Higgs, Thomas, Gibbs.
So we're specifically talking about this case because this is the case before us, and this case specifically has the 1 count that's B1 and J, correct?
Yes. But it is unlike the indictments in the other cases where the prosecutor is clearly unambiguously seeking a conviction for both first degree J. On the one hand, defendant should plead to first degree J, or at trial, the jury should find first degree J. And also that if prosecutor is asking for a separate conviction for 2nd degree B at either plea or trial. And
Your arguments would merge, correct?
So I do agree that prosecutors have, and one of the reasons, this is another reason why this is rational. I don't think this applies to my client, as I made clear, but I do agree that prosecutors do generally have discretion to bring 2 separate counts, even though I don't think that actually is what happened here. So I agree with the state. There's the State versus Connell opinion from the appellate division in the 80s. When a Graves Act crime merges with a non-Graves Act crime, the sentence must be at least equal in length to the mandatory sentence required for the Graves Act crime. If the non-Graves Act crime doesn't permit that long a sentence, the Graves Act crime survives the merger. So I agree with the state, and this is another reason why it's perfectly rational for the legislature to have sought a no mandatory minimum for a first degree offense, and that's because prosecutors have charging discretion when the circumstances dictate or justify it.
Sorry, so just to make sure I understand. So You're saying a prosecutor could charge with a first degree offense under J, or a Graves Act offense under A, B, C, or F, but not both, or yes, both?
Yes, both. So I'm saying a prosecutor could issue an indictment, like in the various unpublished cases I said in my brief, where there's count 1, first degree J, count 2, let's say 2nd degree B, or maybe 3rd degree C. It doesn't matter. One of the 2nd or 3rd degree counts.
Either A, B, C, or F, because those are the predicate.
Yeah.
What you're calling the predicate. Correct?
And then the prosecutor could say, either I'm taking you to trial on both of those counts, or you must plead guilty to both of them in order to have the Graves Act survive merger. And so
I'm not sure how that helps you in this case, because in this case, there was the B1 conviction, and a violation of subsection B1 is 2nd degree, which you said is 5 to 10 years. And here the defendant got 10 years with the 5-year Graves Act parole disqualifier. So wouldn't that all be exactly how you're saying it's supposed to work out?
No, I don't think that the single count of charging first degree unlawful possession is the equivalent of the prosecutor saying, I insist on 2 convictions. Obviously,
Is it a wording error? What exactly are we, what went wrong here?
yeah, I think that during the grand jury presentation, the prosecutor made clear that he's seeking he or she is seeking one charge, that B is an element of J, that it was, and that's the way it ended up, is 1 count on the indictment form. I think the wording of the charge is a little bit confusing because it suggests that like there's 2 separate convictions being sought in this 1 count. But I again, first degree unlawful possession, they're seeking 1 conviction for first degree unlawful possession. It is either number 1, J is a first degree crime and the B is the handgun, is the element of J, or B is a second degree and the prosecutor is noting J as a sentencing enhancement. If I'm wrong and I lose and J is a sentencing enhancement. So I think that the outcome of how just like in other cases, the outcome here should be determined by how this court construes the statute, whether it is a substantive offense or not.
In the grand jury transcript at 37 to 38, doesn't the prosecutor actually say that defendant is being charged with quote unquote both B1 and J?
Sorry, I missed the which transcript?
Grand jury transcript at 37 to 38.
So I mean, the prosecutor may have tried to have it both ways, but again, like the prosecutor at least 1 point said very
Defense
clearly.
counsel didn't object, right?
In the grand jury transcript? No, I mean, the
Right,
defense
I'm
counsel
sorry.
wasn't.
Later on, never tried to address the indictment in any way.
I don't recall that the defense counsel tried to amend the indictment. Rather, defense counsel interpreted it always as being a single count, just as I am, that it's a single count of J. It's not, you're not seeking convictions for both J and B. So, okay, I would ask this court to find that I'm not rapping, but I'm saying that J would be a first degree substantive crime separate from B, that it makes sense because the prosecutors continue to maintain discretion in charging, that judges continue to have discretion to impose a pro disqualifier. And I would ask for relief from my client here because I don't think that he clearly pled to 2 separate convictions. Even if I don't get that from my client, it's clear that generally speaking, in the future, the court should hold that for future purposes, the court should hold that J is a first degree substantive offense, and that it was a rational decision, that the plain language clearly indicates that J is both substantive and not included in the Graves Act. And that therefore, best practice, not even best practice, that when the prosecutors issue future indictments, if they want to charge first degree J, it should say first degree J, A, B, C, or F are an element. If they want to charge.
Slow down with that.
Sorry.
If prosecutors in the future want to charge J,
Yes.
what should happen?
So if they want to charge J, there should be a count that says, contrary to the provisions of first degree J, with, following the elements of the model jury charge, right? That you violated either you violated either A, B, C, or F, and you have a prior near conviction. Therefore, you're being charged with first degree J. And if you want to have a second charge with A, B, C, or F, second or third degree, whether or not the prosecutor is ultimately going to insist on a plea to that, that depends on the individual case. But the prosecutor could also have a separate charge for A, B, C, or F in a separate count.
And you're saying that this would bring about eligibility for the Graves Act parole disqualifier? We're done that way. Is that
Yeah,
what your point with that is?
So if a prosecutor insisted on pleas to both the Graves Act charge and a non-Graves Act charge, of course we're saying that first degree J is a non-Graves Act offense.
Right.
But if the prosecutor wants,
But you're saying, when you're saying that how prosecutors may do this in the future, you're saying this is what they would need to do in order to make the guilty plea eligible for a Graves Act parole disqualifier.
Yes, Your Honor. I mean, there has to be a separate conviction for a Graves Act charge, which I don't think was done here. But in the
I'm
future,
still not understanding. So in order to get a conviction under J if you need a conviction under A, B, C, or F, and you're not saying that the prosecutor has to only choose one or the other, then what are you coming out with at the end?
So it's because
How
it
does
is,
that benefit your client?
of course, it is possible that in some circumstances, prosecutors, decide to go only with the first degree J charge, as I think did in fact ultimately happen here. But there could be other circumstances where the prosecutor says, we'll.
You're not saying they have to choose one. You're saying they can go ahead with both. They get the conviction on J, they get the conviction on B. So they have the Graves Act B and what you call the non-Graves Act J. I'm not understanding if we were to even set forth that rule going forward, which perhaps would be dicta anyway, because it wouldn't be implicated by this case. But if we were to set forth that rule, how would that help a defendant going forward?
A hypothetical defendant going forward?
Correct, because of this defendant, we already said the judgment of conviction says B and J.
Well, it would help defendants going forward because, of course, and this goes to the last point I wanted to make about rationalization. Of course, judges don't, in fact, have to impose discretionary pro disqualifiers for non-Graves Act crimes. So 43(6)(b) says, as part of a sentence for any crime, the court's clearly convinced that aggravating factors substantially outweigh mitigating. The court can fix a minimum term not to exceed 1/2. And that's for the most serious offenses. The judge could have discretion to impose up to half of life, but they don't have to. Discretionary pro disqualifiers are, I think it's like State versus Case. They're the exception, not the norm. Once a pro disqualifier is held not to be mandated by statute, judges can exercise discretion not to impose one. So it is.
They would still have to just impose one on the B, which you're saying is a separate conviction, but can go along with it.
Sure. So you could have a separate conviction for J and another conviction for B. But of course, that doesn't have to happen in every single case.
But that would extend the exposure for any defendant. So a B1 conviction under Graves ends up with a 10 with a 5. And then if there's a separate conviction under J, that same defendant could get a 10 consecutive to the 10 with the 5.
So, I mean, we're talking about some serious cases where prosecutors do insist on convictions for both. I'm saying the circumstances might not always warrant that, or prosecutors might not want to risk going to trial. This case, there's a constructive possession allegation. He wasn't actually observed in possession of a handgun. So you could certainly imagine some scenarios where a prosecutor wants to please someone to just J, make the case go away, and we'll accept that. We'll recommend, let's say, a 10 with 5, but leave it to the judge's discretion.
Could those two offenses run consecutively, or would they merge?
First degree J and second degree B.
Yes.
They would merge. If a defendant was sentenced to a like a 10 flat for first degree without a discretionary pro disqualifier, and then for a second degree, you could get a second degree term with the Graves Act equivalent, and at least under the State versus Connell opinion, when they merge, the Graves Act crime survives.
No, you said they would not merge. I'm sorry.
I'm sorry.
I thought the chief asked if the B and the J convictions would merge, and I thought your answer was no.
Oh, sorry. The Graves Act survives merger, I think, was the understanding of the Connell opinion. The way it was worded was,
so they do merge. So the answer is yes.
They merge, but it says if the non-Graves Act crime doesn't permit a sentence as long as equivalent to the mandatory sentence required for the Graves Act crime, the Graves Act crime survives the merger. And I believe the Connell opinion was relying on a Supreme Court memorandum from like 45 years ago. But that's been the established law for a couple of decades.
Just real quick, even though J has an element that B1 does not, and that is that the state has to prove there's a prior near offense.
So I think that at least for sentencing purposes, my understanding, I would agree with the state that the Connell opinion suggests that at least the Graves Act term survives the merger.
And then upon merger, the defendant could be left with 20 with a 5, right?
Of course, there are circumstances like in Canada where the prosecutor is seeking a much longer sentence, but there's at least an opportunity for a defendant to argue to the prosecutor, to the judge, that no mandatory minimum should apply.
Right, but the first degree would take that maximum to a 20. So in the abstract, upon merger, the defendant could be left with a 20 with a 5.
I mean, yes, in the abstract, look, first degree sentences are from 10 to 20. The prosecutor can make a recommendation within the 10 to 20 range. Under State versus Warren, the court would have discretion to go down to at least to the bottom of the first degree range, down to the 10. And that could choose to, at least for discretionary pro disqualifiers, to not impose one if that is permitted by statute, if there aren't any mandatory minimums. I mean,
But I thought you said here that the mandatory minimum on the Graves Act survives the merger, so there is a mandatory minimum.
right.
I mean, the parole disqualifier.
I guess I'm speaking at cross purposes. So like if there are in fact 2 charges and the prosecutor and the
You're saying
defendant,
there have to be.
sorry.
But you're saying there have to be, correct?
No, I'm saying that the prosecutor can choose, the prosecutor and the defendant can choose to agree to a plea agreement where the defendant is pleading to 2 convictions, one Graves Act and one not.
That's part of your argument that J is a standalone offense.
It's part of my argument that it would be that one of the reasons the state's arguing it's not rational is because that defendants would get out or at least would become eligible for parole sooner. And I'm saying that there is an aspect here that is within prosecutors' control in egregious cases where they want to make sure that doesn't happen, that they absolutely can insist on 2 charges. Similarly, judges have discretion to prevent what they might feel is an egregious result. And of course, the legislature has exchanged minimums for a higher degree.
I want to try to keep this simple and see if we understand you. You're saying that for there to be a Graves Act, you have to charge both counts separately, both J and B separately.
You'd have to ask the defendant to enter a plea to 2 different convictions, and
Yes,
here
that's what I'm trying to confirm with you. That's
Yeah.
your position.
Yes.
That you would have to charge J and B separately for a Graves Act sentence to be part of the ultimate sentence, correct?
Yes, and the reason I guess that
And going beyond that, if hypothetically you got a 20-year on the first offense and a 5-year sentence on the second Section B offense, you're not suggesting that those 2 could run consecutively, correct?
no,
Merger would apply it.
No,
at least
merger would-
insofar
merger
as that is concerned.
yes.
Go ahead.
So we've been talking a lot about would the legislature have rationally permitted this? I mean, to sum up, there is some precedent. I mentioned the 235 statutes. There's also at least one second-degree arson statute that's in NARA, but not a later subsection, first-degree arson for hire, that's not NARA. So the legislature does do this from time to time. And then, of course, there is some room for prosecutorial and judicial discretion here in appropriate cases where, so the results that the state really fears someone who's committed some very egregious crime being let out like absurdly early, that's not really a concern that rebuts the idea that J, based on the plain language, is a substantive offense that is not listed in the Graves Act.
You mentioned in your brief that it's common for substantive criminal statutes to have as an element a violation of a different substantive criminal statute, with the actual citation referring back to the other statute. Can you give some examples of that?
I have like 2 examples that immediately come to mind. So one example is 33(3) false public alarm. So I believe, I was looking at the statute earlier this morning, subsection A makes it a 3rd-degree crime, a false public alarm. Then later, subsection C refers back to subsection A. It says a violation of subsection A of this section, if additional elements are met, is a crime of the 2nd degree or a crime of the 1st degree. And it seems clear based on the plain language that it's not saying, well, A is a 1st or a 2nd degree crime. It's saying that C is, nevertheless referring back to A as like a predicate, element. So that's false public alarm. I would also point to 35(7.1 the 500 feet of a public park, it does require proof of 35(5)(a) is one of the elements of conviction. So it's I maybe maybe I went too far in my brief. I don't know. You have to scour the code as well, but like even
You're
if it's
saying
not,
maybe you went too far in saying it's common.
even if it's not common, it's certainly not
Two is
unprecedented.
not, two is
It's-
common.
It's
Sorry.
not unique. I don't want to be caught in like a speaking too broadly. It's not unique. It's not unprecedented.
Would
3571,
conspiracy-
sorry, required
But-
proof of which? Can you say that statute one more time?
3571
Requires proof of what?
requires proof of a violation of 35(5)(a), which is just the normal distribution statute. And then the false public alarm seems to require proof of a violation of subsection A. And that's in subsection C of the false public alarm
Would
statute.
conspiracy be somewhat like an offense that encompasses another offense? Because in order for there to be a conspiracy, there has to be elements of another offense that was committed in conjunction with others, in an agreement with others.
Yes, I suppose it could. I'll be completely honest. I'm not an expert on conspiracy law, so but I accept that there are other analogs in the code that I haven't thought of.
Can I ask you something about the indictment? Could this indictment in its present form be submitted to a jury without any changes to the structure of the way the trial would be worked out?
So if it were submitted to a jury without any changes to the structure, then the jury would be asked to find whether the state has proven beyond a reasonable doubt that a violation of first-degree unlawful possession of a weapon, which is J.
Wouldn't they also be asked to consider the existence of a near offense in the defendant's prior?
Yes, and that
Problematic in any way?
no, and I mean that's what there would be a bifurcated trial proceeding. That's exactly what happened in the Canadas case.
And that's what I'm asking about. So why don't we just treat this like if certain persons in possession, where it could be indicted separately as a J standalone, either indictment or a J standalone charge that wouldn't be tried in the original substantive direct trial?
Yes, Your Honor. And again, that's exactly what happened in the Canadas case. And so I pointed out in my brief that there is some analogy here between this and the certain person's crime.
But to walk through that then, Justice Wayne Raptor was asking you about it before. Wouldn't it be the case that the eluding and the unlawful possession of a weapon charge would be tried? And they would get through deciding whether or not the jury finds them guilty of those two separate offenses. The unlawful possession of a weapon only going through the B1 stage of the elements. The jury comes back with their verdict. If they find guilty, then a second trial as to J is independently held. If it is in fact a substantive offense and is separate, then they would have to make the findings of the elements of, having found the unlawful possession of a weapon, then finding whether or not a near offense exists in the background. And then that would be their final determination.
Yes, Your Honor. I would agree with that procedure. And I would point out that's how the prosecutor presented it to the grand jury here in order to get the one single first-degree unlawful possession of a weapon charge. It was bifurcated. And then during the second part, the prosecutor told the jury that B is one of the elements of J.
In other words, this could never be presented this way completely because of the possible prejudice that you'd have to tell the jury a near offense exists at the outset, and that wouldn't work, would it?
That's correct. Yeah.
Other questions? Anything you'd like to add at this point, counsel?
No, Your Honor. I'll reserve for rebuttal.
Thank you, Mr. Farmer.
Good morning, Your Honor. May it please the court. To discern whether subsection J creates a separate substantive offense, this court should look no further than the text of the statute, which refers to itself as a first-degree crime.
Counsel, if you'd be more comfortable, you can lift up the podium. There's a switch toward the front. Look up. Look in front of you.
This,
Yeah, I believe there's one there. And if you don't see it, keep going as you are.
is it okay? Can everybody hear me?
Perfectly fine. I wanted to make your life easier. Go ahead.
I'm comfortable, Your Honor.
Go right ahead.
Okay. I can't figure it out. I might as well not even try and embarrass myself. So going back to what I was saying, so both the state and the court below hold the view that subsection J is a sentencing enhancement and not a substantive offense. However, neither the state nor the appellate division were able to cite a single sentencing enhancement in the code whereby the sentence is enhanced by a prior conviction that refers to the increased sentence as a first-degree crime. In fact, it does not exist. In all other cases where the sentencing exposure is increased due to a prior conviction, the code simply states that one is exposed to an extended term. For example, under 2C:44-3, there are 3 circumstances where the sentencing exposure is increased by virtue of the offender's prior record: persistent offender, professional criminal, second offender with a firearm. So those are subsections A, B, and D. Also in 2C:43-6F, which would be your second or subsequent drug offender. All of these statutes mandate that an extended term, not that the person has actually committed a crime of a degree higher. Notwithstanding that the legislature has, for time immemorial, expressed its sentencing enhancement terms by way of the extended term framework, the state concludes it has departed entirely and inexplicably referred to it not as an extended term, but as a first-degree crime. But even if the court were to find that the statute is ambiguous and resort to other principles of construction to discern the legislature's intent, the primary principle argued by the court, by the state and the court below, is that interpreting subsection J as a separate substantive offense not included in the Graves Act sentencing scheme would produce absurd results. It argues that it would be absurd to interpret the statute to allow some first-degree offenders to receive a windfall of a flat term of imprisonment and conceivably serve less time than certain second-degree offenders. But the contrary interpretation is equally absurd. Under subsection J, some offenders will be exposed to an extended term of life imprisonment. Since the Graves Act offers no alternative to the trial court sentencing someone in the first-degree range other than a parole ineligibility period of 1/2, then interpreting subsection J as the state suggests would increase the maximum period of parole ineligibility from 10 years to 1/2 of life in prison. Now, for a regulatory offense, having a handgun without a permit and something that before 2013 was merely a second-degree crime, one could conceivably serve more time in prison than someone convicted of murder. That is equally absurd and unlikely to be the intended result of subsection J. It is equally absurd that the legislature intended to increase sentencing exposure that dramatically, without any reference to subsection J or any guidance to the trial court whatsoever as to how to sentence a first-degree offender in the Graves Act itself. The text is clear and unambiguous. We need not attempt to resort to extrinsic aids to resolve any ambiguity because none exist. The plain language of the text establishes a separate standalone crime, and its omission from the Graves Act is fatal. Simply, subsection J does not carry with it any mandatory period of parole ineligibility. This court should leave it to the legislature to decide whether it intends to include subsection J in the Graves Act and not unilaterally insert it into a statute where it does not exist, as the state suggests. Very quickly, if I could just address one of Justice Winter-Apter's concerns, and I believe, Your Honor, asked Mr. Rockoff something: how do we handle this? How do we handle the way that this judgment of conviction was phrased? I think something the court should look to, as it applies to this particular case, is the plea form itself. So that would be at DSA 3, where it is clear that trial counsel and Mr. Cromedy were under the impression that he was pleading guilty to 1 count of first-degree unlawful possession of a weapon under subsection J. In that count, or in the plea forms themselves, counsel reserves her right to argue that the Graves Act does not apply to that conviction. I think what happened with the judgment of conviction is that the trial judge was attempting to buttress his own position that subsection J is a sentencing enhancement and not a substantive offense, and decided to write both statutes down in the judgment of conviction. But I think it's very clear that from the intent of the parties and from Mr. Cromedy's understanding that he was pleading guilty to 1 count of subsection J.
But there's never been a motion to amend the JOC.
There has not been, Your Honor.
So that issue really, the correctness of the JOC is not before the court, is it?
It is not. It would just be to address this court concerns as to how this court's decision might affect Mr. Cromedy, depending on its decision and how the court rules on this particular issue.
Because in theory, if there was a conviction under B, the 10-5 is perfectly permissible under B, correct?
It is correct. It would be correct. So if Mr. Cromedy did receive a conviction under subsection B,
Which the JOC says, but would say wrongly.
which the JOC says, but I think it was completely contrary to Mr. Cromedy's reasonable expectations. I don't think counsel had any intention on pleading guilty to a separate standalone 39(5)(b) offense. I think it was always everybody's intention that this was going to be a standalone, single count, subsection J conviction. But yes, to answer Your Honor's question, under those circumstances, the B would merge into the J, but the STIP would survive the merger.
Councilor,
So-
it feels like you just conceded that there's a separate offense in the JOC. I have to be honest with you, I don't read it that way, because if there was a separate offense, I see that it's that both statutes are written, but if there was a separate offense, wouldn't there have to be a separate count?
No, I don't think that there's a separate offense. I think that the trial court wrote down both statutory provisions in the judgment of conviction.
Right.
So because it was the source of some confusion with the court, I just wanted to express my belief that I don't believe that there was any intent by any of the parties that Mr. Cromedy would plead guilty to 39(5)(b).
You're here as a friend of the court, not as Mr. Cromedy's counsel. You probably want to stick to broader principles.
Very well. Very well. So my broader points, and to go to obviously to the discussion that Justice Fasciali started, the resort to the doctrine of absurdity, I don't think really gets us anywhere, because I think if you take extremes, you take the most lenient extreme from our position, or you take the most severe punishment that could be offered under the state's view, you end up with two, I think, equally absurd results. So I think what should be done here, and I think the most prudent method of statutory interpretation would be to stick to the language of the text. I don't think there really needs to be any resort to extrinsic aids, because I don't think there really is any ambiguity with that statute. And like I said, there is no other sentencing enhancement that uses the term first-degree crime. They all use extended term. So unless the court has any other.
What about Justice Noriega's certain persons bifurcated trial suggestion?
Right, that would be how to handle the particular statute itself, but even if, so going back to Justice Noriega's suggestion about the bifurcated trial, certainly that would be a way to keep from the jury the fact that this person's a prior near offender. But even if, under our interpretation of the statute, even if the jury were to come back guilty on the final element of subsection J, the graves, and that were the only offense that the jury returned, there was no separate predicate Graves Act offense that were separately charged and convicted, there still would not be a stipulated period of parole eligibility.
I'm sorry, there still would not be what?
A mandatory period of parole eligibility.
Stipulated, did you say period of parole?
Mandatory period of parole eligibility under the Graves Act. So regardless of how J is treated in terms of the real life circumstance of an actual trial, it's not going to insert J into 43-6C where it wasn't placed by the legislature.
But there would have to be an A, B, C, or F offense in the underlying trial, right? So there had to be a Graves Act offense for this to even apply, right? So you'd have an initial trial, let's say it was this case, right? Eluding, and the B1 trial with the weapons offense, and that's a Graves Act offense. And then there'd be a bifurcated second trial on J to see if the state could also obtain a conviction on the first degree. So I guess the question is, if at that point, you now have this finding of the B1 offense and a finding on the J offense, what happens at sentencing with those two charges?
So just so I understand, so is Your Honor asking whether, so if these charges, if this count is bifurcated into two separate trials and the jury comes back guilty on the possession portion, wouldn't there have to be a separate conviction for a 39(5)(b)(1) and also a conviction under 39(5)(j)?
And I guess that's what I'm asking you. And that's why I asked the question the way I did earlier to Mr. Rockoff. If the indictment as it stands were set for trial, how would that be handled? Because I don't believe these two counts could be tried in the fashion in which they're described right now. There's something would have to be done to bifurcate the case.
Well, it would be the same as a 39-7 trial would be a
Versus
certain
defendant
person's,
trial.
would be a certain person's trial.
But the certain persons is usually not incorporated into the possession of weapons charge. You see what I'm saying? It's not usually included in the same count as this is with J.
Right, and I don't think it necessarily needs to be here either. So one could envisage a single count indictment charging 39-5J. And I think under those circumstances, it would be handled exactly as it would be the same way that the prosecutor would handle a 39-7 trial. And with all the safeguards that would be attendant there, it would be the same thing here.
Sorry, so you're saying even if the indictment only charged J, you would still need a bifurcated trial?
I think it would be handled the same way a certain person's trial would be handled.
But this is an interesting point, because I think J is it's almost like a dependent offense. It depends on an underlying conviction for A, B, C, or F. So you couldn't have a standalone sole count indictment on just J. I don't believe that could exist. Do you disagree?
I do disagree. So I think that the model jury instructions are pretty clear. So there are 4 elements to the charge. And those, even though the statute itself makes reference to other subsections of 39-5, I think those elements can be broken up. And I don't think.
So are you saying this could never be done with a single count if it's done in the manner that you say is the proper way to do it?
I think it would,
because bifurcation, how could bifurcation be accomplished if there's only one count?
You need more than one to accomplish
to
that.
accomplish the bifurcated trial. Well, then I'd have to revisit my position.
But I thought the whole purpose of the position was J is a standalone offense and J can be pled as just J.
It can be.
But now we're saying that J cannot be ever charged as just J because you can't obtain a bifurcated trial, but you can't go to trial without a bifurcated trial because then you'd have to admit the prior NERA offense.
But doesn't I believe the same problem would be inherent in a certain person's trial.
But a certain person's indictment can never be, nobody can be charged with just a certain person's offense by itself with no other charges or indictments.
But here you're saying they can be just charged under J.
Well, somebody could be charged with certain. I can imagine a situation where somebody was a disqualifying offender, and they had the firearm in their home, and so there's nothing in violation of 39-5B that would be the problem. The firearm was seized from their home, and they were just charged with certain persons not to have weapons.
But they'd still have to be charged with unlawful possession of a weapon to begin with in some way, shape, or form in order to get to the certain person's offense.
No, I disagree, Your Honor. So I don't think that the only thing in the hypothetical that I'm talking about under that circumstance would be that there's a disqualifying offense and they cannot own a firearm, but there's nothing else about their possession of the firearm that would violate any other statute. So if the firearm were in their home, and they'd be entitled to the dwelling exemption under 39-6E. And so there's nothing about the firearm that's illegal, except for the fact that they have disqualifying offense under 39-7.
And I don't want to get into the weeds about this, but I imagine in that circumstance you're describing that the person would probably have to violate some kind of paperwork regulation because they would have needed to obtain the paperwork to be able to have it in the home, right? This is post-conviction of a prior offense. They're not allowed to have a weapon. They'd have to get the paperwork to have the weapon in the home. So there's at least some offense that would exist there for them to have the weapon in the home without the proper identification paperwork or permits.
Well, I think that the question was, can somebody just be convicted of a certain person's not to have weapons offense without anything else? And so that's my response to that. So I have seen people with a single count indictment of a certain person's not to have weapon. Now that very well may imply, now if a certain person's offender has a firearm in their home, that very well may be very good circumstantial evidence that they got it there by some sort of illegal means. But all I'm suggesting to the court is that I've seen that charge in a single indictment and no other attendant regulatory offenses charged along with it. So I think that because that certain person's the certain person statute can exist that way, this is no different, right? We encounter the same problems that we have to communicate to a jury an element of the offense that could potentially be prejudicial. And that's something that we would have to deal with in the future. My position is that the way that this statute is written, given the plain language of it, it is not in the Graves Act and does not carry with it a mandatory period of parole.
So are you saying that you need 2 counts to bifurcate? Why can't you bifurcate the B1 aspect of it and then try the J aspect of it under a single count?
You very well may be able to do that, Your Honor, but under that circumstance, if that were a single count indictment of J, you couldn't use that one jury finding in half of the bifurcated trial to then give the guy a mandatory period of parole and eligibility, then give him a separate first degree offense, then merge them, and then say the Graves Act.
Because your point is you could only do that if you have two counts.
Correct.
And if you had two counts, you could bifurcate. And if you had two counts, you could bifurcate. And the parole ineligibility period would carry with it.
Correct.
But if you had one count, you could still bifurcate. You could still charge J in a single count indictment. But the point is that your point, I think I understand, is that the parole ineligibility disqualifier would not carry.
That is correct.
Thank you, counsel.
Thank you, Your Honor.
Ms. Comisiano.
Thank you, Your Honor, and may it please the court. More than a decade ago, the legislature saw a need to more harshly punish those with serious prior first and second degree convictions, including homicide, sexual assault, kidnapping, robbery, and more, when they continue to violate the law by illegally possessing firearms. So to accomplish this goal, the legislature enacted subsection J of 2C39-5. Subsection J elevates what is otherwise a crime of the second degree in the case of machine guns, handguns, and assault firearms, or a crime of the third degree in the case of rifles and shotguns, to a crime of the first degree when it is committed by a person with a prior No Early Release Act conviction, like this defendant who had a prior conviction for reckless manslaughter. But defendant is asking this court to hold that the legislature did not intend for the Graves Act mandatory minimum sentencing to apply to this upgraded offense. The appellate division in this case got it right when it looked at the entire statutory scheme as a whole, as well as evidence of legislative purpose, and rejected the defendant's argument. This court should do the same. Based on the discussion so far this morning, I would like to focus my remarks on four main areas and hopefully answer some of the questions that the court has already asked. First, I would like to go through how the plain text of the statutory scheme establishes that the Graves Act applies here. Second, I would address how this grading statute should operate in practice. Third, I would like to address some of the questions the court had about merger. And fourth, I would address the parole consequences and some questions that the court had in that area. And I would welcome any questions the court has as I go through these four areas. So starting first with the plain text, defendant agrees and the state agrees that statutes are not read in isolation. Statutes have to be read as part of the whole entire statutory scheme that they are a part of. So we're in agreement that you have to read subsection J and the Graves Act together. And when you do that, mandatory minimum sentencing applies. As this court had already noted, subsection J's plain language requires, quote, a violation of A, B, C, or F. So really, in short, there is no subsection J offense without an underlying A, B, C, or F offense. This case proves that point. As has already been discussed this morning, both the indictment in this case and the judgment of conviction list the B1 offense and the subsection J offense. I believe defense counsel said that the state didn't seek to proceed under subsection B, but the judgment of conviction specifically lists first degree unlawful possession of a weapon, and it's contrary to B1 and J. The defendant never challenged that. So with that in mind, the defendant is convicted of both. He's convicted of subsection J with the underlying offense being B1. And the judge below, Judge Payon, recognized this as well at sentencing when he said at page 6 of the sentencing transcript, had he not committed B, he would not be subject to J. So I don't think that's really in dispute in this case. So the first part of the Graves Act is met. And then we go to the next part of the Graves Act, which says what the mandatory minimum is. And the mandatory minimum is 1/2 of the sentence imposed or 42 months, whichever is greater. On a first degree offense, it's always going to be the 1/2. So that's what we have in this case. We have a 10-year base term with a mandatory 5 years of parole and eligibility. And then
What are the two counts of conviction under your analysis?
the counts of conviction. So the defendant is convicted of first degree unlawful possession of a weapon in one count, but that necessarily requires that the defendant violated A, B, C, or F. So in this case, B1. So that actually brings me to my second point to,
So that's a second degree conviction. I mean, assume you're correct,
Mhm.
and just for the purposes of this question, that charging someone in a single count of a charging document can result in two distinct convictions that each merit their own sentence. How do you get the Graves Act for the first degree?
so you get the Graves Act for the first degree because the Graves Act, the first part of the Graves Act language specifically says, it lays out the offenses that are subject to the Graves Act. And what specifically for this case, it's 39-5B. The defendant is necessarily convicted in this case of 39-5B. And then you go to the next part of the Graves Act, which says what the period of parole and eligibility is. And that's where you get the 1/2. The defendant is necessarily,
But you're asking for 1/2 of the 10 that was imposed for the violation of J.
yes,
And yet you don't have arguing that there are two separate counts of conviction here. What's the sentence on B? If the judge were to literally apply the Graves Act and give 50% of that.
let me clarify, we're not arguing that there are two counts of conviction. There is one conviction that results in this case, and it's the first degree unlawful possession of a weapon. And if I could analogize, Your Honors, this brings me to my second point, how the statute should work, and I would make the analogy to stalking. I think that's a really good analogy for this offense, and there is case law on it. This hopefully addresses some of the questions the court also had about bifurcated proceedings and how you do these cases. So specifically, this is a greeting statute. So what was a second or third degree crime, in this case, a second degree crime, is now elevated to a crime of the first degree. So the defendant is necessarily violated B1, but that is an elevated offense to a first degree offense because of his prior reckless manslaughter conviction. So to make the analogy to stalking, and this is in 2C.
Before you get to stalking, is the JOC correct that there is a violation of two statutes in defendant's case?
Yes, I think the JOC is correct because you can't get to J unless you have a violation of A, B, C, or F.
Violation or a conviction? I think I wrote down what you said. Yes, you said that the defendant has to have committed, and then you referred to the subsections in order to get to the Graves Act parole disqualifier. But does it require a conviction of both, or does it require that the elements of those offenses be satisfied beyond a reasonable doubt by the state?
I think that the way the legislature intended, even though the subsection J says a violation of A, B, C, or F, if you look at the legislative history, I think they're contemplating a conviction. So in the legislative history, and this is in the committee statements, and I believe both sponsor statements, basically the legislative history explains the provisions of the bill make it a crime of the first degree for a person to unlawfully possess a machine gun, handgun, rifle or shotgun, or an assault firearm following a conviction under NERA.
So shouldn't there be two counts in a case like this? One for the whatever the subsection is that's being charged, and the other for J.
I think that in some cases the state has charged it in two separate counts, but I don't think at the end of the day, if it's charged as two separate counts or charged in one count like this one was done, that ultimately should make a difference. I do think the way this was,
and I may be missing something, but how could you have a conviction for an offense that is not charged?
because I think it is because J is incorporates the underlying offense. So you have to meet the state has to establish that in this case, subsection B1 was violated.
That makes it an element. That doesn't necessarily make it a separate freestanding conviction, does it?
That's true, but it doesn't need to be a separate freestanding conviction. So that's why I do think
But you're arguing that it is, that the J and C is correct. That's what Justice Patterson is focused on.
right, because I think that the legislature was not intending to create a separate offense and then have the defendant, in some ways it's worse for the defendant because they're convicted of a second degree and a first degree. The legislature was intending to take a second degree or a third degree offense, and this is what the legislative history says. Under current law, a violation of these provisions are either a second degree offense, and it lists the type of firearms, or a third degree offense. So if we look at the legislative history, what they were trying to do is anyone who commits an A, B, C, or F violation and has this prior NERA conviction is now subject to first degree subsection J.
Ms. Comisia, can you clear something up for me? I thought your argument from your brief was that J is a sentencing enhancement. And now it sounds as though you're arguing that it is one of two convictions. If J itself, it sounds like you're suggesting it's a standalone offense, which I don't think is where you wanted to be from your written submissions.
I appreciate the opportunity to clarify. We did use in our brief interchangeably somewhat sentencing enhancement and grading provision. The state's argument, just to be very clear, is that it's a grading provision. Sentencing enhancement, clearly, we talked about sentencing enhancement because that's usually in the context of recidivism, and this is a classic recidivist statute, but this is a grading provision.
What's the difference between a sentencing enhancement and a grading provision?
So a grading provision, so a sentencing enhancement doesn't necessarily need to be presented to either the grand jury or the petit jury. In this case, we're not disputing that this should be presented to the grand jury and the petit jury because it does elevate the degree of the crime. So it's not, it's moving it from a second or third to a first degree, whereas a sentencing enhancement doesn't necessarily always change the degree of the crime. It increases the sentencing exposure.
Doesn't that make it a substantive offense like first degree robbery would if there was a weapon involved? Like that's suddenly a separate substantive offense from second degree robbery where there's an absence of an element. So why isn't this a separate substantive offense then?
So subsection J is an offense. Subsection J is an offense. It's just an enhanced offense beyond A, B, C, or F. So I think the stalking statute is a good, I think, framework for how we should look at this case. And there is case law on the stalking statute as well. And I think it's very analogous to what we're dealing with here. So stalking in 2C12-10, subsection B defines what I'll call the core crime of stalking. And I won't read the entire definition, but it defines the core crime of stalking. And then it's a crime of the fourth degree. And it says a person is guilty of stalking a crime of the fourth degree, and it goes on to list the elements. But then we look at subsections C, D, and E, and they make stalking under different circumstances a crime of the third degree. And those are somewhat analogous to what we're dealing with here because it's prejudicial information that you wouldn't want a jury to have when it's hearing the underlying stalking case. So, for example, C is the stalking was in violation of a restraining order. D is it's a second offense, or E is the stalking occurred while the person was in jail or on parole. So if we look at stalking, and there's an appellate division case that I think nicely outlines how this should work. And again, I think it's a good analogy here. It's State versus Lozada. It's 357 NJ Super 468. It's a 2003 case. So what that case says, and it's analogous to what we have here with the model jury charge, and the model jury charge for stalking is analogous as well. The jury should be, and this will go for the grand jury as well, and that was done in this case. The grand jury or petit jury should hear the underlying offense. So in this case, it would be the B1 facts that would present the B1 violation. In the stalking situation, it would be just the underlying stalking. If the grand jury returns a true bill on that, then the jury would be told, we're going to present an amended charge for your consideration, and the grand jury would hear evidence of the prior NERA conviction. Just like in the stalking situation, the jury would then hear that it was in violation of a court order or was a second offense or whatever the case may be. And then if the defendant is ultimately found guilty, if the jury accepts that the defendant had the prior NERA conviction, the defendant is convicted of first-degree unlawful possession of a weapon in violation of B and J. But it's ultimately one first-degree offense, just like with the stalking, it would be one third-degree offense of stalking. So I think by analogy, that works nicely to how this statute should operate.
Wouldn't that only be a conviction under J then, just J? With no, it's just like in the stalking case, it'd be under the whatever the highest degree that the state was able to prove, it'd be under that, and all of the others would drop off.
No, I don't think so, Your Honor. So for stalking, for example, you have to have the core crime under B, like for example, subsection C of stalking says a person is guilty of the crime of the third degree if he commits the crime of stalking in violation of an existing court order. It can't just be under C because we don't know what that doesn't define what stalking is. Stalking is defined under subsection B. So you have to have, by analogy here, you have to have an underlying A, B, C, or F conviction.
But
to
you're
even
only
get-
convicted of one stalking offense.
Yes,
Convicted of multiple stalking offenses. You're only convicted of one, right?
yes, you'd be convicted of third degree stalking. Just like here, you're convicted of first degree unlawful possession of a
And
weapon.
that's not by virtue of merger. That's just, there's only one offense as to which there's a conviction.
Yes, and I will address merger in a moment. But yes, in our view, what the legislature was doing here, and again, we have to effectuate the legislature's intent. In our view, what the legislature was doing was similar to what it was doing with stalking. And this is confirmed by the legislative history, elevating a second or third degree to a first degree conviction, not necessarily having to have two separate convictions and then having them merge. But I would like to address merger because I know the court had some questions on that. And I think merger is actually important in this case because I think it illustrates how the defendant is really trying to have it both ways. So merger, as this court has said in the Dillahay case, and this addresses the school zone statute, merger is grounded in the theory that a defendant who has committed only one offense cannot be punished as if he committed two. So the defendant here is basically arguing to this court, B and J are two separate offenses, but then he's also agreeing with the state that they would indeed have to merge. So what's the point of saying it's two separate offenses if at the end of the day they have to merge, just like in the school zone context? And I know there was a question about why they would have to merge if subsection J has what we're calling the extra element of a prior NERA conviction. And I would just point the court to, well, Dillahay discusses this, but it's also 2C1-8A1 and D1 specifically. So 2C1-8, this is dealing with lesser included offenses. A1 essentially says you can't be convicted of two offenses if one is included in the other.
Could you give us the case again? Renee?
State versus Dillahay,
How do you spell that?
and it's Dillihay. And
I shouldn't be asking that question on St. Patrick's Day, but I did.
And I can give Your Honor the citation as well. It's an opinion from this court. It's 127 NJ 42 from 1992.
Counsel, I think counsel was arguing that there would be merger if there were two counts.
Right,
Here, there's only one count.
right.
So I don't think that for these purposes, counsel was arguing that there would be merger.
Right, but I think putting aside this case, I think what defense counsel's argument is, and he can correct me if I'm wrong on rebuttal, but is that you have to get any type of period of parole and eligibility, you have to charge A, B, C, or F separate and apart from the first degree offense. And then you would get a flat sentence on the first degree. That's what the defendant asked for below. A 10-year flat sentence, that's very clear from the sentencing transcript. And then you would also impose sentence on the underlying A, B, C, or F offense. There would be a Graves Act, and then they would merge. And then you would have a period of parole and eligibility, but it would not be on a first degree offense. It would only be on the second or third degree offense. So I think my argument was that defendant is arguing to this court, these are two separate offenses, but at the end of the day is agreeing that one would be a lesser included offense of the other. So under 2C1-8D1, an offense is included if it is, quote, established by proof of the same or less than all the facts required to establish the commission of the offense charged. So this is very similar to school zone in the Dillahay case. So the subsection A, B, C, or F violation, in this case, the B1, would be established by less than all the facts required to establish J.
So it should merge.
So yes, it would merge if they're charged separately. And my point is that defendant is trying to make them sound like these are two separate offenses, but then if they're charged separately, they would have to merge.
But again, that's not what happened here. So their primary argument is here. They
Right.
weren't charged separately. So the Graves Act doesn't apply. And in an instance where they are charged separately, there would have to be two separate convictions on both counts for all of those sentencing scenarios to play out. So I hear what you're saying, but I mean, for purposes of this case and how this has been charged here, and seemingly how this is often charged, is this how J is often charged in one count along with the B, A, B, C, or F?
So I think it's done a little bit differently in different counties. I think we can see from the unpublished opinions. I know obviously this was a Middlesex case. My understanding also Burlington does it this way. In some of the counties, it's been charged as two separate counts, but I would say that I don't think there should be basically a difference between the way this is charged. To the extent there's confusion, I think this case provides the court the opportunity to help clear up the confusion and answer some of these questions about how should this actually be charged. And so I would propose the following guidance for the court to give to prosecutors and the defense, that basically in short, how this case was handled is the correct way to effectuate the legislature's intent with this statute, protect defendants because they're ultimately only being convicted of one first degree offense at the end of the day. And also it protects from an unintentional windfall, I'll call it, where a jury would potentially, if you only went on J, and the jury would have found that the defendant unlawfully possessed a weapon, but for whatever reason does not accept the prior near conviction, then the defendant ends up being acquitted. That would be an unintended windfall.
But isn't it normally, for example, in the context of a drug case,
Mhm.
one interaction, police observe one transaction, they arrest the individual with drugs in his possession, packaged with multiples. Wouldn't they charge possession with intent separately, possession with, distribution separately, 1,000-foot separately, 500-foot separately? And you have a range of third degrees all the way up to second degrees. Obviously all encompassing one event.
Mhm.
And the person could be convicted of any number of them. So that at the end, some of them would drop off if they were convicted of the highest charge. So the 500-foot charge would be a conviction. All the rest would either be merged or dispensed with separately. But you wouldn't get a separate sentence on the third degree possession that would end up superseding the 500-foot charge, right?
Well, I think the difference when we're talking about drug cases, Your Honor, would be, and also this is why this is different than a certain person's, they're all in separate statutory sections and they're not necessarily cross-referencing each other, whereas here, 39-5J, just like stalking, it's all self-contained in one statute. And I think the legislature's intent was clear to say that you only get a J offense if you violated B, whereas with the drug situation, I don't know that they're cross-referencing each other in the same way.
Tell us your view of the import of the certain person's offense for this case. How does it affect our determination here? What relevance does the certain person's offense have?
Do you, just to understand Your Honor's question, do you mean generally or the fact that he was also charged here with? Generally, okay. So the certain person's offense is different in many ways. Before I get into why it's different, the one thing that I do think certain persons does help us with is to have a model for how the bifurcated proceeding could go. But in terms of certain persons, that's a different analysis. That's clearly a separate offense that can be charged separately and even separately sentenced. So there's three reasons I think that
Can I
certain.
ask you a question? Doesn't certain persons, and I may be wrong because I didn't look this up, but doesn't certain persons have the bifurcation right in the statute?
I don't know, Your Honor, if it's right in the statute. I know it's case law from this court. I believe state
Maybe I'm
versus
wrong that it's case.
State versus Ragland, I believe said that it has to be bifurcated.
Okay, then I
So
could be wrong. I'm sorry.
that's okay, Your Honor.
What are the
Um,
three differences?
So there's three differences. So first, this is kind of going to what I was just saying in terms of the drug offenses. First, certain persons is in its own statutory section, and it does not cross-reference any part of 39-5, whereas subsection J clearly is with, self-contained within 39-5 and cross-references other parts of 39-5. Second, certain persons creates another second-degree offense. Most of the firearms offenses that we're talking about, with the exception of rifles and shotguns, are already second-degree offenses. So it wasn't what the legislature was doing here, which was upgrading anything from a second or a third to a first degree. It was just creating another second-degree offense, and it actually has its own mandatory period of parole and eligibility right within the statute. And third, I think this is probably the most important. If certain persons and unlawful possession are both charged and the defendant is convicted on both, they're sentenced separately. They do not merge. Each one has an element that the other does not. The certain persons has the element of the prior conviction, whereas the unlawful possession has the element of no permit, and there's no overlap there. So they're not the same for the purposes of like a double jeopardy, Blockberg, or Miles analysis, but that would be the case here if we were to view B and J as two separate things. They really end up being the same. And you could actually have, one of your honors asked a question before about consecutive sentencing. You could have consecutive sentencing, and we've seen it on appeal for unlawful possession of a weapon and certain persons. And it's even been upheld by the appellate division. I don't think the defendant would be arguing here today, and I don't think he has argued, because I think he's agreed that they would merge, that you could have consecutive sentencing. So that's why this 39-5J, while superficially it may sound like a certain person's offense, is really not. It's a grading provision that is elevating what was otherwise a second or third degree offense to a first degree offense.
Counsel, you said before, there shouldn't be a difference as to how this is charged.
Mhm.
Isn't that exactly what is dispositive and controlling? Isn't the charge in the indictment, isn't that what puts the defendant on notice? Isn't that generally a manifestation of the prosecutor's discretion and what the prosecutor chooses to charge? So when you say there shouldn't be a difference in how this is charged, it seems to me that how this is charged is exactly what can be dispositive and controlling.
So let me clarify, Your Honor. So I have 2 points to that. First, when I said it doesn't matter how it's charged, I think that was because first, there's been confusion on how the statute operates. And the confusion, to be clear, is not necessarily on the Graves Act and whether the Graves Act applies. So the defendant relied heavily in his briefing, not so much at argument today, on the Mack case. And is it a standalone offense? And is it subject to a finding by a petit jury, a grand jury and a petit jury? That's where some of the confusion has lied. And is it an elevated offense, or do you charge it in 2 separate counts and it ultimately merges? So when I say it doesn't matter, I think this court has the opportunity to decide how this statute should operate and to give effect to what the legislature wanted. But yes, I do think that if you do look at how this case was charged, it is dispositive here, because the defendant's indictment and judgment of conviction both list that he's convicted under B1. And if you look at the plain language of the Graves Act, if he's convicted under B, the Graves Act applies, and then you just go to the next part and you have to give him 1/2 of the sentence that's ultimately imposed.
I understand in this case that could work because the 10 is allowed under the B1
Mhm.
and the 5 is then half of the 10.
Mhm.
So there could have been a conviction only under B1 and it could have been the same thing. But I thought defendant's point was that you could have a conviction under J where the person gets 20 years
Mhm.
and the half of the 20 is 10.
Right.
And that would not be permitted under the B1. So there it's really only the Graves Act applying to J, and J is not listed in the Graves Act.
So in the state's view of the plain language of the statute, if you're getting a 20-year sentence at the top of the range, the period of parole and eligibility is the 10 years. Even though J is not listed, and I have 3 reasons why the fact that J is not listed is not in any way dispositive of what the period of parole and eligibility should be. And so first and foremost, as I've already alluded to, subsection J is, again, a grading provision, and there's no J conviction without an A, B, C, or F. So in some ways, it's actually would be redundant to list J because all of J's 4 core offenses that are elevated are already there.
What if the
But it wouldn't-
what if the statute, instead of cross-referencing A, B, C, or F, just stated if a person knowingly possesses a machine gun, handgun, rifle, shotgun, or assault firearm, who has a prior conviction is guilty of a first-degree crime? What if that's what Jay said? Would it then fall within the Graves Act?
So your Honor, just to be clear, your Honor is saying there is still a subsection J and it doesn't cross-reference.
But the facts of A, B,
Right.
C, and F are encompassed within that. So if the section just said, if a person is, guilty of possessing a machine gun, handgun, rifle, all the elements that you find in those other subsections, but didn't cross-reference those subsections, would you be arguing that the Graves Act encompasses J?
I don't think there'd be, I think we would still make that argument because I don't think it's necessarily that it has to say it's A, B, C, or F. I think there's multiple ways that a legislature could reach
Well,
the
one of the
same.
reasons why this is different from the certain persons is because there are cross-references here. There's no cross-references in certain persons. Could it be that the legislature was just using A, B, the cross-reference as shorthand, so as not having to list all of those different violations? And again, J is not listed in the Graves Act. So if the cross-references weren't there and J isn't in the Graves Act, what would your argument be?
I think it would be maybe a slightly more difficult case if it doesn't specifically list A, B, C, or F, but I wouldn't necessarily concede that point because I think saying A, B, C, or F is shorter than maybe saying, machine gun, assault rifle, things of that nature. But I think here they clearly did incorporate A, B, C, or F into J. Another point that hasn't been brought up yet, that the second reason that the fact that J is not there is not dispositive is, and the appellate division pointed this out, 43.6 D2 of the Graves Act, which was added at the same time as this package of amendments, lists what is excluded and does not include subsection J.
Sorry, can you say this citation
Sure.
one more time?
It's 43-6 D2. And I can give your honors the specific language without necessarily listing all of the types of guns, but basically
It lists guns that are excluded from
from Graves Act sentencing, it's basically BB.
air pistols or what, things like that.
Yeah, spring guns, BB
Spring
guns,
guns.
things of that nature. And that was done at the same time. So to the extent, I guess that brings me to my third point. At most, what we're talking about is a potential ambiguity at the very most. So if we have a potential ambiguity, we don't just go straight to lenity, I think, as the defendant is arguing. What we do is, and this court has repeatedly made clear, looks to other evidence to see if we can determine what the legislature wanted. And if you do that, the state would urge that your honors would find, just like the appellate division did, that the legislature was intending to upgrade this offense And with that naturally would come the punishment. We have to keep in mind, the Graves Act has always been about deterrence. Since the beginning of when it was enacted, this court has made that very clear. And the deterrence comes through the mandatory period of parole and eligibility. That is where the deterrence comes through. And so that would bring me to the final point that I wanted to address, which is the parole consequences.
Counsel, before you go, can I just ask you
Yes.
about a related question? Here's something that I'm having a hard time understanding.
Mhm.
Your argument,
Mhm.
right, is that on 43 B, C, even though it says A, B, C, or F and excludes J,
Mhm.
right? It doesn't include J. J, in a sense, should be read into that for purposes of establishing a parole disqualifier,
Mhm.
right? Why then is it that at sentencing, the state didn't argue that? The state didn't argue that that's why there should be a parole disqualifier. Instead, the state argued 43-6B and didn't touch 43-6C and said, no, there should be a parole disqualifier because the aggravating circumstances substantially outweigh the mitigating circumstances. Why did you come off this argument and argue that the parole disqualifier actually applies for completely different reasons?
So I
And
do
that's
have,
at 12, page 12. of
yeah,
the
I do have the
sentencing.
sentencing transcript. I think, Your Honor, I know that the state certainly preserved its right to argue for the discretionary parole disqualifier under 43-6B to preserve that argument. Presumably, to the extent they didn't argue it again, and I don't recall that, Your Honor, but because the judge had already ruled, that the parole disqualifier was mandatory. So I think the state would be operating under the judge had already ruled, and they were just adding an additional. In no way do I read any
Sorry,
of the
can you say that one more time? The judge had already ruled that you were entitled to the parole disqualifier under C, and
Yes.
yet you instead argued that you should get it discretionarily under B?
No, I don't think it was an instead. I think that it was an additional argument. I do have the transcript in front of me, and I just wanted to double check that because I don't remember the so on pages 9, I believe, and this is the sentencing. Let me just double check that this is the sentencing transcript. At page 9 of the sentencing transcript, going into page 10, the prosecutor is arguing, as Your Honor already said, 5J is a grading statute and incorporates 5B, and it's talking about the jury charge. We can't harmonize the defendant's reading of the statute with what the legislature intended with the Graves Act. So I read that as the state is continuing to assert that the Graves Act applies here. And then on page 11, midway down, about starting at line 10, and Your Honor, even if this offense isn't subject to the Graves Act sentencing, Mr. Cromedy can and should be sentenced under 43-6B. And I think that was probably to preserve for an appeal because the defendant did preserve his right to argue this as part of the plea. And the state may have known that the defendant, anticipated the defendant would raise this issue on appeal, which he did. And in the event that the appellate division disagreed, and I think Judge Payon at one time even said the appellate division may disagree with me. The state wanted to make clear that this 10-5 sentence was justified in a number of ways. The discretionary stip would apply, which the court doesn't have to address unless it finds the mandatory was not applicable. So that's why the judge didn't even, I don't believe the judge made any findings on 43-6B. As we
Counselor,
argued
on that page 11,
yes.
what actually the state is saying, Mr. Cromedy can and should be sentenced to a period of parole, it says and eligibility. I think that's meant to be parole
Yes.
ineligibility under subsection B of 43-6.
Mhm.
And then in summary on page 12, it says, Judge, the state would ask the court to impose 10 years in New Jersey State Prison with 5 years of parole ineligibility and eligibility, but it's ineligible,
Mhm.
pursuant to the Graves Act and pursuant to subsection B
Mhm.
of 43-6. Now, subsection B is the Graves Act.
Subsection C, 43-6C.
Subsection B.
Yeah, 43, and pursuant, I see, 43-6. I think that they were talking about 43-6B, a discretionary period of parole and
But the aggravating circumstance, the whole argument substantively is there should be a parole disqualifier because the aggravating circumstance substantially outweigh the mitigating circumstance.
I think that the state was talking about two different, I think they were talking about, because it says Graves and, I think the state was saying the Graves Act applies, so that's mandatory. So if you have 10, then you have to do 5. But if you're, even if it isn't subject to Graves, then 43-6 would kick in and the court could impose a discretionary step. Yeah, 43-6B
Is the Graves Act.
is not the Graves Act. It is what I've always called the discretionary period of parole and eligibility.
And that would not be before the court on this appeal. Only the Graves Act.
Yes.
Before.
Yeah, 43-6B as part of a sentence for any crime. So it's not just gun crimes, where the court is clearly convinced that aggravating substantially outweigh the mitigating. The court may fix a minimum term not to exceed 1/2. But that's for any crime. That's not limited to Graves Act is firearms.
You're arguing that the B argument was just in an alternative if the C
Yes.
argument was not accepted.
Yes.
Can I ask, you mentioned the purpose of the Graves Act and why the legislature may have chosen to design it in the way that you're suggesting. What is implicitly wrong with a 10 to 20 range for an offender that doesn't match your definition of what the punishment would be under the Graves Act for a second-degree offense?
Just so I make sure I understand your Honor's question, are you saying why wouldn't it be rational for the legislature just to increase the to 10 to 20? Is that what?
Without a parole restriction, why isn't that enough?
Well, the legislature, if they wanted to, they could have done that, but our position is that's not what they did. They wanted to upgrade, and with it comes the punishment. It's very clear from the legislative history that the legislature was intending to upgrade this offense. So this actually brings me to my last point about the parole consequences. So this case has evolved somewhat. The defendant was represented below by different counsel, but so it's very clear below. The defendant's argument was, Judge, don't apply Graves Act, and I should get a 10-year flat sentence. And as we laid out in our brief, it's in a footnote. We reference the parole chart that's promulgated by the Department of Corrections, I believe. And it's the Appendix B. So if you look at the Appendix B, let's take this case, a 10-year flat sentence. Earliest eligibility, which includes maximum credits, is earlier than 2 years. It's 1 year, 11 months, and 5 days. Even latest eligibility is 2 years, 6 months, and 21 days. So even latest eligibility is less than 42 months. Now, the argument has somewhat evolved over time, and I think if I'm understanding defense counsel's argument correctly, they're saying, well, the defendant's not going to serve less time because if the defendant is also charged under the subsection B offense, then they'll get the period of parole and eligibility that attaches to that, and it would survive the merger. We would agree with that as a backup, but our primary position is that the legislature wanted to upgrade the offense, and upgrade comes with that punishment. There really would be no purpose to upgrade the offense, but then have no period of parole and eligibility that attaches, and the state still has to go and charge the second or third degree offense to get a 42-month or I believe it's 42-month parole disqualifier on either the second or third degree. The state's not getting anything additional.
This happens sometimes, right? I mean, in this case, if we're talking about the bottom of the first degree range or the top of the second degree range, there's a chance that the penalty might be similar, but you have the discretion of making that recommendation 12 or 15 or 17 or 20. And then the parole would be much higher, right? The first eligibility would be higher.
Well, so, even if you're, I apologize.
No, go ahead. You were going to say that the parole eligibility would still only be 3 years, 4 years.
Yeah, even if, I think you have to go up to even 17, when you go up to even 17 years, again, this is in Appendix B. It's not appended to our brief, but there should be a link as to where you can find it. Even 17 years, you go all the way up to 17 years, which is pretty high at the top of the range. You don't necessarily always see a 17-year sentence, especially, for example, this case, this defendant is getting the bottom of the first degree range with a prior homicide and a criminal history that dates back significantly. So he's not even getting at the top of the range. So you'd have to go up to a 17-year sentence would get you to earliest eligibility at less than 3.5
But should we
years.
take into account the realities of how parole is usually dealt with, and that somebody who did get a 10-year flat sentence with a prior homicide
Mhm.
and a NERA offense and a current gun offense is probably not getting out on their first eligibility and could potentially max out, which is higher than the stipulation of 5.
I mean, perhaps, but we're still talking about even like on a 10, for example, their latest eligibility is still well below the 3.5 years. It's more like 2.5 years.
Their max out date is
Oh,
that?
no, that's their latest eligibility for parole. But I don't think that I think the legislature is presumed to be aware of parole consequences. And that's why it enacted mandatory periods of parole and eligibility, because it wants to ensure that these dangerous recidivist offenders who, again, they have a prior homicide, a kidnapping, a sexual assault, a robbery, these are the most serious offenses. And then they're out and they're still undeterred and they're committing another firearms offense. The legislature wanted to ensure that they are deterred, and how you deter that and deter other defendants is to remove them from any potential eligibility for parole for as long as the 1/2 of the sentence imposed.
Looking at the clock, I want to try to bring this argument to a close. Is there anything you haven't covered you wanted to address?
I do not believe so. I think I did. Let me just look at my notes real quickly. So just to sum up, in this particular case, as we've talked about, this defendant could end up with the same sentence in a number of ways. It could be a discretionary step, even if the Graves Act didn't apply. It's the top of the 2nd degree range, and the defendant could certainly get that. But this case presents this court with the opportunity to give guidance beyond this case as well. And in the state's view, the appellate division got it right when it concluded that the legislature intended for Graves Act mandatory minimum sentencing to apply to these recidivist offenders who continue to violate the law and now possess guns. And this result flows from the overall statutory scheme, the legislative purpose, and the common sense of the situation. And we would ask this court to affirm the appellate division's decision.
Other questions, anyone? Thank you.
Thank you, Your Honors.
Mr. Rockoff, 5 minutes on the clock.
Cognizant rebuttal time is always short. I'll just make 4 quick points that go directly to this being a substantive offense that doesn't require the Graves Act. So one, my adversary made reference to Jay. It was described in the state's brief as being, a sentencing enhancement. The alternative they're saying is, well, maybe even if it's just not a substantive offense, maybe it's a grading enhancement. Well, Jay, in addition to not having sentencing language like she'll be sentenced, she'll serve a term of imprisonment, also doesn't have grading language, right? It doesn't say that it's a statute for grading. The legislature is actually pretty good about employing the grading term when it needs to. I cited a couple of statutes in my brief where they do that. 13.1, the kidnapping statute, 15.1, the robbery statute, 18.2, the burglary statute, 22, the theft statute. They specifically note like this portion is a grading statute. They didn't do that here. Second, my adversary says, well, in 43.6F, the Graves Act, no J notation is needed because A, B, C, and F are already there, and it would be redundant. Well, it wasn't redundant for the legislature to list J in 39.5 when they clearly distinguished it from A, B, and F, which are A, B, and F convictions, which are present, and also distinguishing it like a C plus NERA from barring someone from ISP versus a plain C conviction, which wouldn't. Third, it's our position that this court, the plain language is unambiguous. To the extent that you reach the sponsor statement, I want to point out that upgrade isn't a technical term. I found it was used in at least one recent sponsor statement where the legislature like unambiguously created a new offense. That's the bill that created a new burglary crime, despite the sponsors there also saying the amendment was an upgrade. That's L 2024, Chapter 83. And I just quoted this, but the sponsors said in part there, this bill upgrades the crime of burglary of a residence, and it would additionally upgrade the burglary of a dwelling to a first-degree crime if there's a deadly weapon present. And that bill unambiguously created a new crime. So three.
It unambiguously created
a new crime,
crime.
despite having used the word upgrade in the sponsor statement. So I definitely don't think that's dispositive. And fourth and finally, I just want to address D2 of chapter 43, which lists some exemptions. So first of all, looking a few sentences above at 6B, the presumption is a mandatory minimum isn't required just because it doesn't say one is required, right? 43.6B suggests, well, unless it's specifically mandated elsewhere, a parole bar is discretionary. At 43.6D2, it's true. It lists some specific exemptions from the Graves Act mandatory minimum, but that really doesn't flip the presumption here of no mandatory parole bar for basically the following reason. 43.6C, the Graves Act, right above D2, already states that A, B, C, and F are certain designated crimes that qualify for Graves. All 43.6D2 was to say, well, except for these a mandatory minimum is still required as per 43.6C in A, B, C, and F, except for B2, C1, and sometimes C2. So that clearly leaves part of B and part of C in the 39.5 in the Graves Act, which the legislature stated were designated crimes, and that's contrasts with this situation where there's no comparable need for the legislature to specifically exempt J, which the legislature never in the first place designated in 43.6C, the Graves Act, as being included. So those are the main points I have. I urge this court to vacate the mandatory pro disqualifier and order a resentencing. Unless there's any other questions, I would submit.
Thank you for that succinct rebuttal. And court will take the matter under advisement.